Alhamdulillah, nahmaduhu wa nasta'inuhu wa nastaghfiruhu wa na'udhu billahi min shururi anfusina wa min sayyiati a'malina. Man yahdihillahu fala mudilla lahu wa man yudlil fala hadiya lahu. Wa ashhadu an la ilaha illallah wahdahu la sharika lahu wa ashhadu anna Muhammadan abduhu wa rasuluh. My dear respected viewers, brothers and sisters, today inshallah we're continuing with session 2 of the Wills and Inheritance workshop that we started. And as I said in the last workshop, this is something that we need to continue because the Prophet Muhammad sallallahu alaihi wasallam instructed us to teach this, to learn this knowledge and teach it. And in another hadith mentioned that this is one of the first types of knowledges that will be removed. So it's something that we have to continue bringing awareness and teaching. So today we do have a guest, a very special guest, the Mufti Kaleem Muhammad. And Mufti Kaleem himself has been teaching at the Jamia in Marbella, Jamiatul Ulum. And he has been teaching this topic of inheritance himself. So he has a lot of insight, alhamdulillah. He has a lot of experience as well with dealing with the shares, looking and explaining it from the Quranic perspective and the Sharia itself, from Quran and Hadith. And he has been doing a class for everyone, it's for public as well. So he takes it from a very basic level, and he's taking it over a span of time. So you have enough time to kind of absorb some of that information. So today he will be explaining some of that, and he will be going into it in a summarized version. But do remember, and I will post that out to everyone, inshallah, anybody wants to study it in depth and learn the science itself, because one of those knowledges that is important in Deen and will help bring a lot of ease and comfort for many of the families that would have difficulties when a loved one has passed and did or did not leave a will. So the more awareness that we bring, inshallah, the easier it will become. So I will send that class, inshallah, that will be starting in September, to everyone on email. For those who signed up, if you did not sign up, please WhatsApp us, and we will send you the link as well to sign up and to get all the information. So we'll put our number on the chat as well. So please WhatsApp us if you did not get the link previously, if you didn't register, because those registered will get all of the information that we keep sending over. And just to remind anyone who had personal issues that they wanted to solve, you can send a message to the WhatsApp group as well, and we can make an appointment and we can start that process for you, inshallah, and we can advise you. Both legally, we have a legal representative that helps, and Islamically as well. Myself and others, we look at it and we try to give you solutions to these types of issues that you may be facing. Lastly, inshallah, just to mention, after Mufti Kaleem's session, which should finish at 3 o'clock, inshallah, we have another lawyer, Sister Soraya Lachman. So she's been working in this space as well, doing wills and so on. So she will have approximately 15 to 20 minute presentation about the legal aspects of the will and what is required and what is the practice in Trinidad and Tobago. And maybe we might have a little 5 to 10 minutes question and answer session with her. And then afterwards, I will be closing off the session for today, inshallah. So without further ado, I will ask Mufti Kaleem now to join us, inshallah. Mufti Kaleem.
الحمد لله رب العالمين والعاقبة للمتقين والصلاة والسلام على سيد الأنبياء والمرسلين سيدنا ونبينا وشفيعنا وحبيبنا وقدوتنا محمد بن عبد الله وعلى آله وصحبه أجمعين أما بعد السلام عليكم ورحمة الله وبركاته. To all and everyone, to each and everyone, especially Mufti Abrar and the Al-Ihsaan team for allowing me this opportunity to present in this platform. My task today is the summary of the shares and heirs. Right? To summarize is very difficult. The time allotted is a little less than an hour. So inshallah, bi'idhnillah, we hope to cover the shares and the heirs type in a manner that is what understood. Type everyone has a general understanding. Bi'idhnillah. Type so inshallah we'll start right away. Summary of heirs and shares. Type our first slide. We have Mufti Abrar, he would have what mentioned the importance of inheritance and what is inheritance. So this is just a small 2 minutes introduction here. Right? What is inheritance in what in common term in what in simple language, inheritance is the automatic transfer of ownership after death onto specific individuals in specific portions. Right? When a person dies, his estate is automatically transferred onto his heirs. What does that mean? It means that what we, the living people, we do not transfer ownership. Right? That is a divine transfer. When the moment a person dies, that ownership is transferred onto his heirs. Right? We, as the living, our duty is to what distribute. It's like a person give what? I give you $10,000 to give Zaid. That $10,000 belongs to Zaid. Your duty is to what? To distribute it to Zaid. And this is inheritance type. Sometimes we feel that okay, we give when a person die, we give what? The estate to this one and the other. No, that is already given to that person. Type. All we do is distribute. So the moment a person dies, that estate transfers upon or transfers until his what specific individuals, and these specific individuals are the heirs of that person, and these individuals are specified by the Sharia. Right? Who is going to inherit? We don't say who is going to inherit. When we are alive, yes, we can say who we're going to give, who we're going to grant, and who we're going to gift our assets and our property. But the moment we die, our our heirs are specified. How much they're going to receive, we can give what? While we are alive, we can give our daughter the same, we give our son. We can give what? Our neighbors, we can give anyone we want to give, we can give. But when a person dies, his heirs are specific. Not only his heirs are specific, how much they are going to receive is also what's specific. So that is why we always see that what? Many people, uh, the will that they write is invalid in the initial state when they say, when I die, my son will get this and my son will get that. When I die, my daughter will get this and she would get that. Her share is what's specified. The share of what each and every heir, that is specified. So we cannot specify type other than what the Sharia has specified. So this is what is inheritance. Type the condition for inheritance. For inheritance to take place, there are three conditions that are necessary. Three conditions that are necessary for inheritance to take place. First, the death of the deceased, the death of the testator, meaning a person only when he dies, this concept of inheritance will take place. A person is on his dying bed. We don't distribute his inheritance. That person is in ICU. That person is in a critical stage. The doctor said that, you know what, he's going to die any moment. Until then, the wealth belongs to that person, is not transferred onto his heirs. So that person, the death must be confirmed and verified. Only then inheritance would take place. Secondly, the presence of an heir, meaning what? The heir who would legally inherit from that deceased, he must be alive. Right? He or she must be alive at that time. And normally we have a situation where there are simultaneous deaths. Right? For example, a death caused by a car crash, and in that vehicle there were husband and wife, or father and children. Right? So now normally a son would inherit from a father, but if in that instant we cannot verify that that the father died first and then the son died afterwards. We cannot verify that, and most likely both of them died at the same time, right? And if we cannot verify that, okay, the son, he died secondly, then the son will not inherit from the father. So why that is mentioned, normally yes, both of them would die, yes, but what happened? The son would inherit from the father, and then after the heirs of the son would receive his portion. So it's very important to verify the presence of the heir. For example, a person died, a grandfather died, and the grandson, if the son the son has a grandson, but that grandson, if that grandson was was in the womb of the mother, Meaning what? The mother was pregnant for that child at the time of the demise of the grandfather. Then what? That child becomes a legitimate heir. He can what? He can inherit. Meaning what? If once the presence is there, but if that pregnancy came after the demise, then he has no share from that estate. Right? Meaning what? If he was an heir. And thirdly, we have the absence of impediments. A person being an heir. Right? Inshallah, we'll see the definition of an heir, what qualifies a person to become an heir. Right? But the impediments, these are the mawani al-irth. These are those things that would prevent a person from inheriting. Right? And basically, there are two factors that prevents a person from inheriting. Ikhtilafuddin, right? Where what the difference in religion, meaning what a person is not a Muslim. If a person is not a Muslim, then he has no right to the inheritance of a Muslim, and vice versa. So it is very important. A person what he dies, right? He has a son, right? He has a son, but his son is what, a non-Muslim. Then that son cannot inherit from the estate of the father. Right? The son cannot inherit from the estate of the father, and vice versa. A son dies, he leaves behind a father, but that father is what? A non-Muslim. That father would not be able to inherit from the estate of the son. And similarly, the condition of that deceased, meaning what? Of that heir. If a person dies, for example, he dies and leaves behind a son who is not a Muslim, then that son will be what? He accepts Islam before the inheritance could be distributed. Right? Would that son would that son be liable to receive inheritance? No. Even though why he would not be able to receive inheritance? Because at the death of his father, right, he was a non-Muslim then. Right? So yes, the conditions are the death of the person must be verified, the presence of the heirs must be there, and also what? The absence of impediment. The second impediment is that of qatl. A person what? He kills that person he can inherit from. A person kills a person, that relative he can what? Inherit from, then that would prevent him from inheriting from the estate of that person. If a person what? Kills his father, kills his son, kills his mother, kills his sibling, kills anyone that he can normally what? Inherit from, that action would cause him to what? Be deprived of the inheritance. And when you speak about killing, right, whatever form, meaning what? If it was done intentionally, unintentionally, mistakenly, right, whatever form it occurred, then that person would be prevented from inheriting from the estate of that deceased person. Right? And the definition of an heir, all these things we have that I mentioned over here, that is mentioned is what in common terms that you know each and everyone can understand. The definition of an heir, who is an heir? Like as we mentioned before, we cannot stipulate who will inherit from our estate. The heirs are stipulated by the Sharia. Right? An heir is a person who is entitled to inheritance from the estate of the deceased because of two reasons. Right? That person, because of blood relation, being what he has what blood connection to the deceased, that would entitle him to inheritance, right? But not all blood relatives they would inherit, right? But blood from the blood relatives, there are those who would inherit. Inshallah, you'll see that there were different categories of heirs, right? The first category, second category, third category. So the first what factor is that of blood relation, and the second is that of marriage. Right? When we speak about marriage, it's only what? Husband or wife. Right? Husband or wife. And these as are stipulated clearly in the Quran, right? As we're going to see inshallah. So if you understand that what a person can only be an heir, right? A person can only be an heir through what? Blood relation or zawjiyah, meaning what? Being a husband or a wife, meaning what? Things like fosterers, adoption, in-laws, ex-spouse, illegit what? Child, illegit spouse, type, all these things what? Would what? All these things would prevent a person from inheriting, meaning what? Would disqualify a person from being an heir. For example, a person what? A person, a man and a woman type, they they're living together type. If their marriage is not acknowledged, is not considered what to be a shari marriage, then what? You're not going to get husband and wife, and children born out of that marriage now type, the connection they would not be what connected to the father type, and so forth type. So there's a whole big study over here type. Who becomes, inshallah, we're going to study, okay, the share of a wife, the share of a husband, and the children. But before that type, is this person a legit wife? Is this person a legit a legit what husband, are these children what legitimate children, only then type they would inherit. Type we have what there are three types of heirs. Type three types of heirs. Primary heirs, which are called what Quranic heirs, type, or heirs that has fixed shares. Type primary heirs, there are 12 primary heirs, 4 males and 8 females, and these are their shares: a half, a quarter, 1/8, 2/3, 1/3, and 1/6. Type these why they are called primary heirs. Type ashabul furud in the Arabic language. Ashabul furud, those people who are given what who shares are specific. Type these people who shares are specific, they will be given their shares first. Type hence what the name primary heirs. These are the heirs who would receive their share of inheritance first. Type also what in this category, heirs inherit simultaneously. Type the heirs inherit what the father would inherit together with the mother and the daughter and the son and the spouse, like that. The secondary heirs, type what is called asaba or residuary heirs. These are the heirs, they don't have a fixed share. It doesn't mean that they won't inherit from the estate, but their shares are not fixed. What happens? The primary heirs, after receiving what their portion of the estate, whatever remains, it would go to what the secondary heir or the secondary heirs. Right? And the primary heirs, as we mentioned, they can inherit what simultaneously. But with regards to what residuary shares, type secondary shares, only one person, type only one person or one category would inherit. Type they cannot what the residuary heirs don't simultaneously inherit. Only one category would inherit. Type from the secondary heirs. Then we have what tertiary, meaning what ashab yani zawul arham, meaning what more distant blood relatives. And this category includes all those who are not from the first category and the second category. All those what distant or all those blood relatives that are not from the first category nor the second category, they form the third category. And this third category is normally termed what non-heir. Why? Because this third category would only inherit in the absence of the first and second any category. Meaning what? If all the individuals type cease to exist in the first category and the second category, only individuals of the third category would inherit, type with the exception of the spouse. Type meaning what? If the spouse is present, meaning the first category, type you can have what? A situation where the spouse inherits with those from the third category also. So this is just all the primary heirs over here, as we can see. Type we have the deceased. Type we have what? The mother. We have the parents, grandparents, spouse, siblings, children, grandchildren. Type inshallah we deal with all of these. And this is what? The secondary heirs. Type. And this is the priority sequence also. Type at the top is the son. Type. And if you look at each category has what? Individuals. Type. The son category, there's grandson and there's descendants of the grandson. So it means that if a person dies and leaves behind a son, that son would what? He would receive residuary shares. Type. A person dies and leaves behind a grandson. Type. That grandson would receive. Type. Or great grandson. Type. He would receive residuary shares. Type. In this what? In this order. Type. The father, the specialty of the father is both a primary and a secondary. Type. He's first what? A primary heir, and there's a possibility also that he receive what? Residuary shares. Type. And obviously in the absence of the son, there's a possibility that the father he receives both primary and residuary shares. Type. So this is what, when we speak about inheritance, this is what normally what this is the estate over here. When a person dies, these are the rights connected to the estate. And if you look at what the inheritance is at the bottom, what does that mean? The rights connected to the estate, and this is what the order of, this is the sequence. Right? First, when a person dies, what he leaves behind, it doesn't go to inheritance. This is called the gross estate. The gross estate refers to what? When a person dies, everything that a person owned until his death, right? Without deducting any of his liabilities. Right? So the first thing that must be deducted, as was mentioned before, the funeral expenses and debts. Right? After deducting funeral expenses and debts, you have what you call the net estate. Right? The net estate refers to that portion of the estate or that part of the estate where the funeral expenses has been paid, right? And the debts of that person has been cleared, right? Has been settled. And the debts over here, the debts owed to what individuals are not religious or what obligations, right? Religious obligations would fall under what wasiya and will, right? So this part of the estate over here, right, which is called the net estate, this is connected to what? The beneficiaries of the will, if there is a will, right? And the heirs of the inheritance, right? So this part over here, the net estate, this is what the net estate, right, is connected to. There's a highlighter here. Okay. All right. So this portion of the estate over here, the net estate, this is where this is connected to the wasiya, if there's a wasiya will, and the inheritance, right? The heirs. Right? So what does that mean? It means that what, at time that if a person he dies and the amount of debts he has in his estate, the amount of debts that he owes, right, it is more than the estate that he left behind, is more than the value of the estate that he left behind, then what's going to happen? We're going to find a situation where there's what? No inheritance, right? We're going to find a situation where there's no inheritance. So meaning what? If a person dies, left out what, the estate of what? For example, $3-4 million, but then his debts type is 3-4 million or more than that, then there's nothing like what? Inheritance in this estate. This estate is still what? An insolvent estate, and this estate would go to the creditors and not the heirs. There are no heirs. The heirs will not receive anything from this estate. Right? Why, as you mentioned before, I stated before that you have learned before that the settlement of debts, it takes precedence, right? It takes precedence. And just on this point over here, many a times we hear a person he dies and he leaves what? Debts behind, right? And many times we hear that what? The creditors are told that what? The person has no money, he didn't leave any cash behind, right? He owes what? $50,000-$60,000, and when the creditors come now, they are told that, listen, the person didn't leave any cash behind, right? Understand here, when a person dies, the value of his estate is taken into consideration, right? So if he left behind a vehicle, he left behind what? Assets, he left behind property, houses, these things has a value. So if a person what? His creditor comes now to claim what? These assets must be liquefied, right? It must be liquefied, and the creditors must be paid off, right? Unless the creditors, they what? They're willing to what? Forgo their need, right? But if what? The creditors are not willing to forgo their need and what they are claiming what rightfully belongs to them, then we cannot say the person didn't leave behind cash, right? These assets, it must be liquidated and the creditors must be paid off, right? So this is the case of an insolvent estate, right? And many a times also this what in the estate is such that what? If it's an insolvent estate, then many a times what? It is not sufficient to pay off each and every creditor what is rightly owed to them. So what's gonna happen? They will be paid in what? In a proportion, the proportion of what? Of what? Their debts to the total debts of the deceased. Right? But we have a little example over here. We're not going into the example type because of the time constraint, but inshallah the slides would be made available. The slides are what self-explanatory, and inshallah you'd understand it through the slides. Right now, today is what? This is what's supposed to really be the first slide. Type is shares. So when we speak about shares, these are all the shares. Types of inheritance is not very difficult to study. Type the shares mentioned in the Quran is what? A half, and half of that is what? A quarter, half of that is 1/8. Then you have 2/3. Half of that is a third, and half of that is 1/6. Right? Simple arrangement, simple sequence. Right? So the only 6 shares. When you speak about shares, type the primary heirs, type they allotted what? Fixed shares. These are the fixed shares. Only 6 what? 6 shares. Right? And normally the hardest thing in inheritance is what working out the LCM. But if we have denominators like what? Like these over here, the largest your LCM going to be is what? 24. Right? So it's simple maths, standard one maths, probably less than that too. Right? So these are the shares, 6 shares. Now we have what? The different approaches of the different what? Authors. Right? Those who have written books in inheritance. Right? Many of them start with what? The approach is what? The fraction. The fractions that we see over here, that we these fractions type, they would what? For example, a half type. So they would list all the heirs type who would inherit what? A half, and the different conditions that what exist type for them to what? Inherit a half. And then those who would inherit a quarter, those who would inherit what? 1/8. That is one approach. The second approach, this first approach is what? Very common also. The second approach is also very common type, where the author, he will take what? All the males and what? And give their cases and explain, okay, the way how they inherit, and then after start with the females type. And there's a third approach, which what? In my book or my booklet type, I found it to be very what? Simple and easier to understand type, where I categorize the heirs into different into what? 6 main category. If you see over here, we have what? The spouse. There's one category: spouse, parents, grandparents, children, grandchildren, and sibling. 6 what? Categories. And from what? Each category, those who would inherit, as we see in the spouse category, both what? Husband and wife, they would inherit. As for the parents, both mother and father, they would inherit. If you look at the grandparents category, we see what? All the 3 grandparents inheriting, meaning what? From the primary heirs, except the maternal grandfather. Except the maternal grandfather. The maternal grandfather is from the 3rd category type, the more distant, or that category which inherits in the absence of the first 2 category. If you look at the children category, we would see only the daughter type, where the son is. On the son is king in inheritance, but the son here is not a primary heir. He is what? A secondary heir. He's a residuary heir whose shares are certain, except what? The amount is not fixed. Right? As for the grandchildren, we have one also what? This is the paternal granddaughter type, the paternal granddaughter. As for the paternal grandson, he is also from the 2nd category, the residuary heirs. The maternal grandson, the maternal granddaughter, they are from the 3rd category. And we see from the siblings, we have what? The full sister, the paternal half sister. As for the full brother and the paternal half brother, they are from the residuary category, secondary heirs category. And then we have the maternal siblings, without distinguishing between what? The male and the female. Maternal siblings mean what? Maternal brother, maternal sister, they are from what? The primary heir category. So this is, I see this to be what? A simpler method type, a simpler approach, an easy approach type. So now we start directly with what? The first category of spouse type, husband and wife, their shares type. The husband and wife, both of them, they have what? A larger share and they have a smaller share type. It summarizes husband and wife into one, inshallah type. Both of them, they have a larger share and a smaller share. The husband, his larger shares are half. The wife, her larger share is a quarter type. And the smaller share for the husband is a quarter, and the smaller share for the wife is 1/8 type. The shares of the husband and wife are only affected by the presence of children and grandchildren. But children, grandchildren, meaning what? In the absence of children, grandchildren, and anytime we speak about grandchildren, we speak about paternal grandchildren, the children from the son of the deceased type, the children from the son of the deceased types. Only children and paternal grandchildren, they would affect the shares of the husband or the wife. So in the presence of any one of them, the husband would get his what? Smaller share. In the absence of all, the husband would get his larger share. Similar to the wife type. The wife, in the absence of children, grandchildren, in their absence, she would get the larger share. In the presence of any one of them, type, she would get the smaller share, which is 1/8. Type. And all of these what are mentioned clearly in the Quran. Type. As for the spouse is never deprived of inheritance. Type. The spouse, whether it be the husband of the wife or the wife, they are never ever deprived of inheritance. Type. So this is the first category of the spouse. We have examples here, but we don't have much time to go into the examples. Type. If, now we have from the parents category, both if anyone have any questions, please we can keep it to the end, inshallah. Right? The inheritance of the parents, so both mother and father, they would inherit. Right? Both mother and father, they would inherit. Right? As for what? We'll start with the father. The father, he has what? 3 cases. I mean, the first case that the father could inherit what? Primary shares, meaning what? 1/6. Right? He can inherit 1/6 of the estate, or the second case is what? He can inherit what? Straight residuary shares. Type. Or he can receive 1/6 plus residuary shares. Type. 1/6 plus secondary shares. Type. And who affects the share of the father? The share of the father is only affected by children and grandchildren. When we say grandchildren, paternal grandchildren. Type. We cannot go a little, we have to go a little fast, right? But as for what? That 1/6, when he would receive that 1/6, he would receive that 1/6 in the presence of the son. Understand, when we speak about any heir, son, grandson, type, mother, grandmother, grandfather, all is in relation to the deceased, type. All is what? A vertical what? Relation, type. The relation to the deceased, type. As we spoke about what? The inheritance of what? The spouse, type. The inheritance of the spouse. If a person dies, type, leaves behind a wife, type, that wife could either get a quarter or 1/8, type, in the presence of a child. Understand here, this child is connected to the deceased, type. It could be that what? A person, what? He has a child from a previous marriage. Now what? He's married to this woman, type, and this person dies, type. So this couple, what? No children was produced from this marriage, except that this wife, she would what? Inherit 1/8. Why? Because of a child belonging to the deceased husband, type. Even though that child may not belong to that wife, type. So everything, it goes back to the deceased. All relations goes back to the deceased, type. Residuary, type, inshallah, this could be read from the slide, type. We go to the rule, type. The father, type. The father is never deprived of inheritance, type. However, he eliminates the following. He eliminates the grandfather, and he eliminates what? The paternal grandmother, which is his mother, type. The paternal grandmother, and he eliminates also all siblings, whether it be full sister, whether it be what? Paternal half sister, brothers, full half, maternal, every type, all siblings he would eliminate, type. So as we see in the example here, type, no sibling, no brother, no sister that would inherit in the presence of the father. The grandfather also would not inherit, plus what? The paternal grandmother of the deceased, right, which is the mother of the father, would not inherit in the presence of the father. Right? As for the mother has 3 cases. Right? The mother has 3 cases, and those who affect what? The share of the father are the same who would affect the share of the mother. As we mentioned, children, grandchildren, right? But in the case of the mother, 2 or more siblings would affect her share. Right? Understand? Those who affect the share for other heirs, meaning what? In their presence, right? In their presence, other shares could be what? Partially deprived or totally deprived. Right? There are certain heirs that are never ever totally deprived. That is what? The husband, the wife, the father, the mother, the son, and the daughter. They are never ever totally deprived, right? But there are heirs that could be what? But however, they could be partially deprived, and this is what we speak about partial deprivation. Like a mother, she would get 1/3, right? But that would be in the absence of son, grandson, daughter, granddaughter, 2 or more siblings, right? If any one of these are present, then she would get what? Her lesser share, which is what? Partial deprivation, right? So the mother, she would inherit 1/6 in the presence of any of these following, in the presence of any of the following over here. Right? Also, if none of these are present, then she would get her larger share, which is 1/3 of the entire estate. Right? But the mother has also a third what case? Right? A third case is where she inherits 1/3, but not 1/3 of the entire estate. 1/3 after the spouse's share has been deducted. Right? But this is what they call a special case scenario where a spouse inherits, right, with both parents of the deceased. Right? A spouse, whether it be a husband or wife, inherits with the mother and father of the deceased. Right? Right? In this case, the mother, she would not get 1/3 of the entire estate, but she will get 1/3 after the spouse receives his or her a specific share. Right? So the husband, after receiving half of the estate, right, then the mother will receive 1/3 of what is remaining. Right? The daughter, not the daughter, but the wife, after receiving what 1/4 of the estate, right, then the mother will receive 1/3 of whatever is remaining from that. Right? So that is what the inheritance of the spouse, husband, wife, the inheritance of the parents, both mother and father. Now we have examples. The examples from the grandparents category. Right? From the grandparents category, there are 4 grandparents, except that what from the primary heirs category, only 3 of them would be 3 of them are qualified what, or 3 of them are primary heirs. That is what, the paternal grandfather and both grandmothers. Right? Both grandmothers, paternal grandfather. As for the maternal grandfather, as we mentioned before, he belongs to the 3rd category. Right? The paternal grandfather, he inherits what? Similar, in the same manner in that of the father. Right? The same manner, right, as the inheritance of the father in the absence of the father. So what does that mean? The paternal grandfather, he would only inherit if the father is absent. Understand, when we speak about the father is absent, right, it means that the father, what, he died, or the father is what, non-Muslim. Right? Only then would the paternal grandfather inherit. And how he inherits in the same manner that the father would inherit. Right? Except in what? 2 cases. Right? Except in 2 cases, and inshallah they could get that from the slide. Right? We're going to go into that amount of detail. Right? And we have examples over here. We see the paternal grandfather being deprived of inheritance due to the presence of the father. Here we see the paternal grandfather receiving 1/6, right? Receiving 1/6, right? And we see, right, the examples over here. Here what he inherits the same manner, right, in which the father would inherit, except in 2 cases. The children, look at the children category. As we mentioned, we're speaking about primary heirs. So from the children category, only the daughter is a primary heir. As for the son, as we mentioned, his son is what? King in inheritance. Type. He is king in inheritance. Listen, the son would what? Eliminate, type, all the grandchildren. The son would eliminate all the siblings, type, to ensure that what he has, type, a share in the inheritance, and he has the biggest share in inheritance, type. But he is what from the 2nd category, a residuary heir category, right? So from the children category, the daughter is a primary heir, and this daughter, understand, this daughter, she inherits what? 1/2 of the estate, right? If there's 1 daughter, 2/3 of the entire estate if there's 2 or more daughters, right? If there are 2 or more daughters, right? So here now the inheritance of the daughter, right? There are 2 types of inheritance. She may either what? Inherit solely as a primary heir, or she could also inherit as what? A residuary heir. Right? Inherit as a primary heir. This is in the absence of a son. If there's no son, yes, she would inherit as a primary heir. Inheriting as a primary heir, 2 cases: 1/2 of the entire estate where there's 1 daughter, 2/3 of the entire estate where there are 2 or more daughters. Right? As for being what? A residuary heir, this is where the presence of what? The son. Right? This is where the son, if the son is present, then both of them would receive what? Residuary shares. What does that mean? All the primary heirs, they will be given what? Their share of the estate, and whatever remains, type, it will be shared amongst what? The son and the daughter in a ratio of 2 to 1. لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ, where the son will receive twice the amount of the daughter. Type. And we have the people normally what over here raise what? They have what? The concept that in Islam, inheritance is what? Shared based on what? Based on gender. Type. Why is it that what? The daughter, why is it that the son receive what? Twice the amount? Why is it that a male receive twice the amount of what? A female? Type. People who don't understand what the laws of the Sharia. Type. Understand. There are many cases, type, when a female inherits, type, there are 4 different ways, type, if you categorize in 4 different categories, type, ways a female inherits. First is what? The inheritance of a female, type, is equal to that of a male. Type, there are many situations where equal to that of a male. We see what? The father receiving a 1/6 and the mother receiving 1/6, the grandfather 1/6, the grandmother 1/6. Type, we see what? Many situations where the male and the female, the inheritance are equal. Type. Then afterwards we have what? Cases where the female inherits and the male is deprived totally of inheritance. Type. There's deprived totally of inheritance. And then also we have what? We have cases where the female inherit more than that of the male. Type. And we have one category, one case where the inheritance of the female is what? Half the amount of the male. Type. That is not in all situations, all cases. Type. And that is through the divine what? Wisdom and hikmah of the Sharia. Type. So we continue what? The daughter is such an heir that she is never ever eliminated. Type. However, she eliminates the maternal siblings. Type. Examples, inshallah, you could get it from the slides. Type. Now we have the grandchildren. From the grandchildren category, we have only the paternal granddaughter. Type. We have the paternal granddaughter. And the paternal granddaughter may receive what? Primary shares or residuary shares. Type. Meaning what? She's a primary heir, type, but she also can qualify to receive what? Primary and secondary. Type. Being a primary heir, she's entitled to receive a half of the estate, 2/3 of the estate, 1/6. A half in the presence of what? One granddaughter. Obviously, in the absence of the son eliminates. Understand? The son eliminates, as we mentioned, all the grandchildren and all the siblings. Type. So, in the absence of the son, the grandson, type, the daughter and the granddaughter, she will receive half in the presence of one granddaughter, 2/3 in the presence of 2 or more granddaughters, 1/6 in the presence of one daughter. That one daughter will receive half, and whatever, and that 6 that remain would go to the paternal granddaughter or granddaughters. Over here we see on top over here grandson and daughter. Understand? The grandson and the daughter or the granddaughter, they do not eliminate what? The granddaughter, type, except what they would prevent her from receiving primary shares. Type. This granddaughter may also receive residuary secondary shares, and this is in the presence of a grandson. Type. The presence of a grandson, the grandson would transform her into a residuary share where both of them receive the residue of the estate in a ratio of 2 to 1. Type. لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ, as mentioned in the Quran. Type. So the paternal granddaughter, like the granddaughter, eliminates the maternal siblings. Examples. Type. This is what the last category. Type. So we're in time. Alhamdulillah. Type. This is the last category. Type. The last category, the category of the siblings. So if you look at the siblings, so we have, look here, look at the siblings. We have the full sisters, the paternal sisters, and the maternal siblings, the maternal brother and sister. Type. These are the primary heirs. Type. As for the full brothers, they are from the secondary heirs. The paternal half brother, secondary heirs. Type. So their inheritance are like this. They can what? They receive what? Primary shares, and also they can receive secondary shares. Type. Meaning what? All primary heirs, if they are what? They can be transformed by a male agnate from that same level. Type. Into what? secondary heirs, type like this, like what the daughter is a primary heir, but she will be converted into a secondary heir in the presence of a son. Type a full sister, she's a primary heir, but she will be converted into a secondary heir in the presence of a full brother. A paternal half sister, she's a primary heir, she will be transformed into a secondary heir in the presence of a paternal half brother. We have what? A paternal granddaughter who's a primary heir, but she'll be transformed into a secondary heir in the presence of a paternal grandson, and like that. So the siblings, we start with what? The full sister type. She would receive what? A half and 2/3. A half in the presence of one sister, 2/3 in the presence of 2 or more sisters. Obviously, look at what? This inheritance, what? These are the conditions must exist. Type. For the sister to receive a half, type, this is what? In the absence of a daughter, the absence of a granddaughter, brother, and full sister. Type. And also, as we mentioned before, type, she would only inherit, full sisters would only, and siblings on the whole would only inherit in the absence of a son, grandson, father, grandfather. So that's understood. So these 4 are absent, and also what? These here also absent. Type daughter, granddaughter, brother, full sister. Type daughter, granddaughter, and brother. Type. It doesn't mean that the brother would eliminate the sister. No, the brother would transform her from a primary to a residuary. Type. So a half and 2/3. And also understand there are 3 types of, when we speak about what? Residuary heirs or residuary shares. Type. There are 3 types. Basically what? There are those what? Residuary heirs who by what? Virtue of themselves. Type. They themselves what? Are by nature are what? Would receive what? Shares. They are not dependent on what? Anyone type to become a residuary heir. Type. They by their own what? Nature, their own virtue, they qualify to be what? Residuary heirs. Type. So we have like that of the son, the grandson, type, the father, type. We have what? The brother, and like that. Type. And there are those what? Who what? Are initially primary heirs, but they are transformed into what? Secondary heirs by a male agnate. That type of what? Residuary shares what? It's going to be always what? 2-to-1 type, where that male and that female would inherit the residue of the estate in a ratio of 2-to-1, like what? Brother, sister, brother and sister, son and daughter, like that type. And there's a 3rd category of what? Residuary heir. This is what? A ladies only category. This is where a daughter or a granddaughter transform a sister, whether it be a full sister or a paternal sister, into a residuary heir, where the daughter or the granddaughter would receive what? Their primary shares as normal, but that sister, whether it be what? A full sister or a paternal half sister, they would receive what? The residue entirely, the entire residue of their estate. Right? So this is what? The inheritance of the full sister. And examples, then we have inheritance of the what? The paternal sisters, and inheritance of the maternal siblings. Type. We're just going through type. And this last slide, type, last 3 slides, this is what? A summary of what? All the primary heirs. Type. We skip the last 2 because of the time. Type. But this is a summary. What? These 3 slides here is a summary of what? All the primary heirs. Type. The conditions. Type. We start with what? If you see the husband, he receives what? A half. He could receive a quarter. What are the necessary conditions? And who what? He eliminates, and like that. So this is what? For all the 12, 13 what? Shares. Type. So this brings us to the end of our of my presentation. I hope it was beneficial. So Jazakumullah khairan. I now hand over the mic to Mufti Abrar.
And Jazakallah for that insight of some of the shares, Mufti Kalim. So as I said, Mufti Kalim does have a class which is a little bit more in depth that discusses the shares, and Unfortunately, the time frame that was given was a short one, so he had to then try to concise all of the information that he would have tried to cover. The point is that the shares itself, some of them are fixed, some of them go to a secondary fix, and some of them go to a residuary amount, or what the person will get afterwards if other people are not there. And it is quite individualized because every single person will have a different type of family makeup. So I just want to remind everyone, inshallah, that we can help you as well if you want to just understand the shares that you'll probably get, or your children will probably get in the current situation that you're living in. And so that's something that we can help with, inshallah. So I'll place a link in the chat box where you can actually sign up, and we would help you work out the shares that you have within your family. So per se, you want to go ahead writing a will, you'll be able to, inshallah, know the shares Islamically that is right now standing. And as I mentioned in last week's topic, that it can change if some member of your family changes. For example, someone passes away, or a child is born, for example, or someone changes their faith, for example, and becomes a non-Muslim, and that can be an issue that happens sometimes. So inshallah, keep that in mind. Right. So anyway, without ado, we have with us Ms. Soraya Lachman, who's an attorney at law, and she will be going through some of the legal aspects, inshallah, of wills and inheritance and what it means to in Trinidad and Tobago, especially because most of our participants are from Trinidad and Tobago. And she will answer, well, we probably won't have much time for question and answers, but you can send question and answers in the chat and also to our WhatsApp number. We will be able to, inshallah, answer them for you over time. And as I said, there's a link there in your chat in the Zoom. You can sign up that form and we will help you, inshallah. And we can even give you a quote if you want to get a will written up. Remember, these wills can be easily adjusted over years if you write it up once and so on. But for now, inshallah, we have with us Soraya, and Sister Soraya is, inshallah, going to go through the wills and inheritance from a legal perspective in Trinidad and Tobago. Welcome, Ms. Soraya, inshallah. Assalamu alaikum.
Assalamu alaikum, everyone. So today my task is simply to go through the legality of making a will. So before we get into the actual legal requirements in making a will in Trinidad and Tobago, I wanted to reiterate the importance of a will, especially to my brothers and sisters in Islam, simply because if we die without making a will in Trinidad and Tobago, we would have died what we call legally intestate. Intestate means that we have died without making a will. And if we die without making a will, our property would be divided according to the laws of Trinidad and Tobago, and it will not be Islamic. So our property would be divided according to the Administration of Estates Act. And how that usually goes would be, it's quite different from what Mufti spoke about earlier in relation to shares and the allocation of to son, daughters, grandchildren, etc. So just quite simply, if we died without making a will, all of our property, once there's a spouse, 50% would go to our spouse, whether our spouse is Muslim or non-Muslim. The other 50% of our property would be divided equally between our children. There's no one else to receive a benefit if we die without making a will. So to reiterate, a will is very, very important, both from an Islamic perspective and generally, you get to allocate how you would like your property to be distributed upon your death. So it's important that we have wills. You get to decide how your property would be divided. So without that will, the laws of Trinidad and Tobago takes control of that. division, and there's nothing we can do as to the division of the property and the sharing of that property. It is shared according to the laws. So with that being said, I wanted to go through the legality and how exactly, what is important in making a will. You do not need to go to an attorney to make a will. However, it is advisable that the person who's making the will has some knowledge or has knowledge of the laws of Trinidad and Tobago to ensure that your will is a legally valid will and can stand up in the courts of Trinidad and Tobago should there be any issues or any queries or claims against your estate. So a will, firstly, is a document which only takes effect upon our death. So it's called a testamentary document. So it does not take effect until the day we die. So a lot of people, a lot of my clients come to me and they would ask me, but if I make a will, am I transferring the property outright? No, I am not transferring the property outright. That will takes effect only upon your death, and it can be changed before you die. So it's important to remember that it's testamentary in nature, and it takes effect, or it only becomes effective when the person dies, when the testator or the testatrix, as we call them legally, when they die. A will must be in writing. And when we write a will, there must be a level of certainty in this will. That is important because when we are probating the will, we must be able to decipher who gets, what they get, and how much they get, because we do not want complications arising in relation to names. So we might refer to your son as baby boy, or your daughter as dots, or you want to be very specific in how you refer to people. So you want to be mindful of using correct legal names. So we have certainty of who gets the property. We then need to determine what they are getting. And as the Mufti went through with you in terms of allocation of shares, we have to know as well what they're getting and how much they're getting. So that's really important when we are drafting a will. So it's something that you take your time and you actually sit down and you think about it. And when we're speaking about what property we have, it's important in creating a will that we have a complete list of everything that we own. When I say everything, I mean everything that you own, everything that you can put a legal title to, everything that you can say belongs to you. So let's go through some basic assets most persons would have. We have a house, land and house. We would have bank accounts. We would have jewelry. We might have properties outside of our home. We may have now foreign accounts, and foreign property are dealt with according to the laws of that land. We only make a will in Trinidad and Tobago to take into consideration our properties in Trinidad and Tobago. We also, everything that you would like to give and to dispose of when you die, that's the complete list that you must draw up of all of your assets. Now, sometimes when people are drafting, when people are doing a will, they may leave out something. And that's why a residuary clause is very important, because a residuary clause can catch anything that we may have left out in the will, or anything that we may have left out in terms of our assets. So the residuary clause must be drafted very carefully to ensure that we take certain things into consideration. Now, sometimes if a complete list is not drawn up of all of our assets, and we make a will and there's no residuary clause, we would die what we call partially intestate. So it means that some of our property would be divided according to the will, and then the other parts of our property, which we did not take into consideration, would be divided according to the laws of Trinidad and Tobago. So again, it complicates the situation, and it would not be divided in an Islamic way. So it's very important that we remember when we are creating this will that we know for certain, or we say with certainty, that this is my property, this is what I own, and this is what I would like to put in my will, and how it should be divided when I die. And of course, how and how much a person receives will be determined based on the Sharia laws. So that's important to take into consideration. Now, when you also have your list of your assets, our beneficiaries are important, right? We must list our beneficiaries clearly. And in doing so, I must make mention to you that a beneficiary must not be a witness in a will. If a beneficiary is a witness, then okay, so I'll answer your question in a little bit, right? Just give me 1 second, right? A beneficiary cannot witness the will. If a beneficiary witnesses a will, then we question the validity of the will. And when we question the validity of it, because we are wondering, why is the beneficiary witnessing? Did the beneficiary in any way influence the testator or the testatrix, the person making the will, into giving them something? So it may cause a situation where one of the other beneficiaries may want to challenge it. So it's important that we do not have our beneficiary as a witness. So these are some of the important elements in creating the will. But I can't forget that, and I have to make mention of other important things. So besides it being in writing, besides us having listed, knowing all our assets, taking into consideration our beneficiaries, making sure we have a residuary clause, making sure our beneficiary is not a witness, there are 3 other important elements in this will. We must always have our will attested to, our signature attested to, by 2 witnesses. So the testator, testatrix, who is making the will sign the will. That's one person. And then we must have 2 independent witnesses who are not beneficiaries in the will, who will sign as witnesses. We must also in our will nominate an executor if it's a male, an executrix if it's a female, or we can have more than 1 person. That person has a very important role in when you die. So when we name an executor in our will, it is important that we know that person will probate our will when we die. So I've seen circumstances and situations where a will was made and the executor does not want to come forward and probate the will. It is not for the beneficiaries to probate the will. It is not for the witnesses to come forward. It's the executor who has the duty, based on being the executor, to come forward and actually start the probate process, because they are the ones who will administer or share the property, or have the power by the courts to share the property according to the to what these dispositions were made in the will, or according to what you wanted in the will. So it's important that we choose somebody who we know will act according to the instructions and act according to the law, and make sure that our beneficiaries get what is deserving of them. So it's important to choose an executor who will do that. Now, if the person who you chose does not want later on, after you've passed on, to probate the will, we will then have to apply to the courts to have that person renounce their executorship. We'll have to do a renunciation of their executorship, which makes the process a little longer. But I mean, it does happen. It's not going to be the first time it will happen, and it will not be the last time it's going to happen. ever. So but it's still important to give some thought into who you want your executor to be. Your witnesses as well. It doesn't have to be family. It can be someone who, and they don't have to read the will. They don't have to know the contents of the will. They are witnessing your signature, right? They're not witnessing the contents of the will. They're witnessing you signing your will as being of sound mind, memory, and understanding. So that comes now to me speaking about your legal capacity to create a will. When a person is creating a will, so many times I've had situations where persons have come to me to make a will for their parents. You cannot take instructions from a child to make a will for your parents. Why? Because it raises an alarm as to why is the child, now the parent may have asked the child, hey, can you get a lawyer for me? I want to make a will. No problem. That is good. That's okay. But the instructions on how the property should be divided must come independently from that parent. It must not be the child say, well, my mother sent a list to me and this is what she wants in her will. I need to verify that with the mother or the father because I need to hear it from them. I need to know that this is what they want. Because too many times I have come across situations and complicated situations where it is not what the parents wanted. So when I speak about legal capacity, anyone can make a will once they are legal, they're 18, they're legal, they're an adult, right? And they own property. And they have things in their possession. And it's not just about owning property, but it's also you can state how you want to your funeral expenses to be paid, your testamentary expenses, meaning probating of the will to be paid. So you have other things in the will as well, besides the distribution of your property. But coming back to the point of the legal capacity of the person making the will, they must be of sound mind, memory, and understanding. So a person who has lucid moments, or a person who may have bouts of dementia or who may be diagnosed with Alzheimer's, in that situation, their will will not, they will not be able to make a will because of their legal incapacity, right? Remember, they are not of sound mind, memory, and understanding, and they would not remember. They might know what they're saying now, but they may not remember this 2 days from now, or they might remember it 5 years from now. So it's important that we take all these things into consideration when we are making a will. So I had a situation where a daughter wanted me to make a will for her mother, but never wanted me to meet the mother. And I was very skeptical about the situation because I never got to talk to her. I never got to meet her, ask her what, how she wants the property to be divided. The daughter was just insistent that this property needs to be left to so and so and so. And I said, no, I'm not making this will because I need proper instructions from the person who owns the property. And that's the next thing. You must actually own the property and properties. So when I say property, I don't mean land alone. Anything, any asset, your bank account. You can't will something that does not actually belong to you. Yes? Right. So just to recap what I've done, I've spoken to you about the importance of making a will from a legal perspective, also from an Islamic, in the point, not as your obligation or to make the will, but from the point of view that if you did not make a will and you died intestate, the property will be shared according to the laws of Trinidad and Tobago, which will not be in accordance with the Sharia law. So everything as the property, so your son will get an equal share. He will not get more than a daughter, right? So it's important that we take that into consideration to remember why we need to make a will from an Islamic perspective as well. We went through the legalities in creating a will and making a will, that it must be in writing. We spoke about the witnesses, appointing an executor, creating a list of all of your assets, everything that you own, bank account numbers, where it's where it's held, who your beneficiaries would be, and the allocation, how much we are giving them. Always check for residuary clause in your will. Residuary meaning that, and whoever is making your will, ask them to explain to you what they're doing, because a lot of time people go to places to make documents, any kind of document, and it's not fully explained to them what is the importance of these clause or statements that are being made. We spoke about the importance of your beneficiary not being a witness in a will and getting 2 independent witnesses. And your signature must be attested to by your 2 witnesses. That's important. Right, just one other thing I wanted to touch on in relation to land and property. We have, a lot of us would own property with if we're married, we would own property with our spouses as joint tenancy. So joint tenancy would mean that it's our matrimonial home, or it doesn't have to be your matrimonial. I'm using the word matrimonial because you're living in that house now, but it could mean that you have a house, a beach house in Tobago, and it's held in your name and your spouse's name. But you hold it as joint tenants. Joint tenants means that no one owns a share. Joint tenancy means that we hold it as one. So it means that myself, Saraya, and A owns that property as joint tenants. We own it as one. And according to the laws of Trinidad and Tobago, the rule of right to survivorship applies with a joint tenancy. So rule of right to survivorship means that the person who dies first does not have a share in that property. That property will then be left to the next person on that joint tenancy, which may be A. So if I were to die first, I don't get to pass that property or that share onto anyone in my will. It automatically goes to person A, my spouse. And then my spouse can dispose of the property. Now, sometimes we can create what we call a mutual will, which can take into consideration joint tenancies, where a husband and wife own property as one, and the husband and wife will have the identical will, meaning that he would say that now that my wife has died and I am the owner of the property, this is how we want the property to be divided, or vice versa. She would say in her will, now that my husband has died and I am the sole owner of the property, I want the property to be divided. And it's identical. That's why they call it mutual wills, right? And that may arise in some circumstances. So I have one other thing I wanted to speak to you all about, right? Just I need to remember that. So we have joint tenancy. We have another term for property, how property is held, as tenancy in common. And tenancy in common means that we hold property according to our share. Share meaning 50%, 20%, 30%, 60%, 75%, however we bought it, that's how we own it. And most times you would not find a husband and wife owning property as a tenant in common. You would find them owning property as a joint tenancy, because they may have taken a joint mortgage, right? I'm just saying, not everyone takes a mortgage, right? But if that's the situation, it would be joint. If it's a tenancy in common, it means that we each own a share. And whatever is our share, we can will it. So a lot of times you would see that this tenancy in common with children, where parents may have left property to children, and it's 6 of them, 7 of them, 5 of them, and they actually allocate a share in the deed, and they say that it be held, or in their will, and say that it be held as tenancy in common. So that's important to remember when you are creating your will. Another thing that some persons may have insurance policies, etc. Make sure that whatever whatever you own, your assets, that you do not already have a beneficiary allocated to it. If it's a bank account or something of that nature, make sure that you do not already have, or even a policy, make sure you do not have a beneficiary already allocated to it, because if that's the case, then that beneficiary will take precedence over the will, because that's what you named in the particular document. Right. So I wanted to mention one other thing before I take questions. Right. So recently I was doing a will for an elderly person, a couple, and it's a husband and wife, and they own the property jointly. It's an Islamic will that they wanted, right? Done. Now, they did not follow the laws of Sharia when it comes to the allocation of shares, right? How the property was supposed to be divided. And that was one debate that I had with them. And the other part of it was that they wanted one will done. You cannot make one will for two persons. A will is personal to you. You cannot have a will with your name and your husband's name on it unless he's a beneficiary or you're a beneficiary to his will. So you can't do that, right? And I had a lot of difficulty explaining that. So it became very, the relationship broke down in terms of me explaining why we couldn't, because they only wanted to pay for one will. And I understand that, but you cannot make one will for two persons. And the second thing was, it's one property, one house on one piece of land. And they wanted me to put in the will that the front bedroom goes to this child, and the back bedroom goes to this grandchild, and the downstairs goes to this other grandson. Now, it was not being shared Islamically. So, but forgetting that fact, you cannot, it's difficult to say I'm leaving a bedroom for someone. The legal part of the property has to be left for people who you know will has legal title to it. So you can't have legal title to a bedroom. That becomes difficult. You can't get a deed for that when we probate the will. So I understand I understand we work hard for what we may have, yes, and you would want to leave your inheritance to people, to your grandchildren, your children, etc. But you have to remember that when you're being advised that as to how the property is to be divided and complicated dispositions, be mindful that sometimes it may not always work out how it may not be exactly, you can't put a bedroom for someone, right? I just use that as an example. Okay, so I just wanted to mention that, right? So let me just answer some questions at this time. Okay, so if a person, so first question is, what is a situation with marriage to wife via nikah, right? So a nikah is recognized Islamically. It's not legally registered. It's not a legally registered marriage, right? So in that situation, if you're living with the person, you can create a will and leave for them. That's okay. You can create a will, but if there's no will, then that spouse, that wife whose marriage is by nikah only and not legal, under the rules, if there is no will, then under the rules of intestacy, the spouse doesn't get. She'll have to make a separate application as a common law spouse, right? Now, if there is a legal spouse in the situation, then you'll have both the legal spouse and the common law applying to get, and you would have to, there's a certain procedure that we'll have to follow to apply for that letters of administration. But if there is a will, everything is much simpler, because that wife who is via nikah will be able to get, which is another thing, right? Once you are legally married to someone in Trinidad and Tobago, although you may be separated from them because of whatever reason physically, you still need to make sure and leave something for them in your will. because they have, by the fact that you have not left and they're still your legal spouse, they can challenge your will, and we don't want that situation. So the second thing is with multiple wives. If there are multiple wives, my advice would be to the husband to ensure that a will is done, because it's only the first or legal wife who, as I said, takes precedence, and then you have to prove that you are a common law spouse, and then you have, so it complicates, especially if there's more than two wives, one legal, one by nikah, another by nikah, so it becomes complicated. So in that situation, the spouse must and should have a will. The next question, as I indicated last week in Barbados, where a spouse is left less than one half the estate under a will, the spouse can elect to take them out. Right, okay, so in Trinidad and Tobago, you don't have to leave them one half of the estate, but you have to leave them something small, especially if you're not, where the spouse is not, I'm not talking from an Islamic perspective, I'm talking about if you're legally still married to someone, but you don't live with them and your relationship has broke down for whatever reason. It may be that the person is non-Muslim, you or your husband, you need to leave something small, right? Because it's still just to make sure that we don't have any issues in terms of challenging the will, right? So that prevents that. So if a beneficiary predeceases the testator, that gift will be void, it does not take effect, and that property will go into residue, unless you actually make a provision in the will that should the beneficiary predecease me, then it goes to another person. You can make that provision in your will as well, but it's important to take that into consideration if you feel for some reason that may happen. Oh, in Barbados, no. If you are still legally married to someone, and if you have had a complete separation, right? Like a complete separation. So we are separated for 5 years and we have nothing to do with each other. And I've been living I nikah'd someone and I'm living with that person as my spouse. That person, once they can bring evidence and where children are involved, then it makes it easier to prove that you are in that relationship. But there are some people who would be legally married still, not in a physical maybe, but still maintain a relationship. That person may very well still be entitled. Okay, so when it comes to inheritance, from the legal perspective, all of the children, whether from the marriage or outside of the marriage, will be entitled if it's under intestacy. If you have a will, you're able to put exactly what and who gets what according to gender, right? Because earlier Mufti was speaking about the son being king in the estate, right? So in the inheritance. So it's important that we have a will to take into consideration our stepchildren or children who we may have not with our legal spouses. No. So if we have a will, right, then this pool of beneficiaries will not really exist because it will be according to the will at the time of your death, right? So whoever you left property, whoever is alive. So yes, you are correct. It's whoever is alive and who's inheriting from the estate according to your will. Same thing with intestacy. Do we have any other questions?
Assalamu alaikum. Sorry, it might just be easier for me to speak rather than type at this point. In
Sure.
relation to the, all right, so I understand that the Islamic pool of beneficiaries is only those beneficiaries of the relevant relationship who are alive at the date of the death, right?
Yes.
But if you've left a will,
Yes.
and let's say, for example, you at the date of making your will, you know, for example, you have one son, two daughters, one spouse. So you may leave specific devices at that point in time, or even if you have a residuary which says it's to be split up amongst these these 4 beneficiaries in X shares, because you can of course work out those exact shares at that point. I guess my query is really, okay, so how I would deal with it in Barbados would be that my residuary clause also says who are alive at the date of my death, and in the event that any of them is dead, then an Islamic scholar certifies who those beneficiaries ought to be and their shares.
Yes,
Right?
you can include that. Yes, that is actually a perfect. Recently, Mufti Abrar and I had done a will, and we included that as the residuary clause. We did.
Okay. Oh, because I only raised it because if you're limiting yourself, you do a will that says, yes, these are my beneficiaries, these are their Islamic shares, this is what I'm leaving to them. But then
Yes.
you run into a problem because none of us knows the time at when we or anyone else will die.
That's correct.
So if one of them predeceases, then the will to an extent then still creates an issue, actually.
That's right. That's correct. That's very correct. And
Right.
that is why the residuary clause is so important, to ensure that we capture anything that we may have left out or did not or couldn't take into consideration at that time. Because of course we would have made this will before we died, right? Way before, because we are, as you rightfully say, we don't know, right? So we, of course, it's whenever we make it for whenever we need it. And that's where the importance of the residuary clause comes in. That's really important. Yes.
All right, I do have one final question, and I'll just mute again because I had come in later. I'd missed whatever Mufti had said. What is the situation Islamically if let's just say there's an accident and both spouses
Right.
die.
Right. Okay. So both died, right? And the
Mhm.
question is, who dies first, right?
Yes, in relation Islamically, what's the answer in that? How does it work, Rob?
Okay. So I will answer from what we will consider from the legal perspective, right? From the legal perspective, the older one would be deemed to have died first. If we don't know who died. So we arrive at the scene of an accident and you pull out both parties and both parties are dead. It could be that the older one died after, because by the time the emergency team arrived, we don't know. Both parties are pronounced dead at the scene. The law automatically deems the person who's younger to have died last. Unless we see that the older one is breathing still, whether it's by a pulse, but whether it's by a whatever, we know that that person is still hanging on. We would then see that person dies first. Or I mean last, right? So I really did enjoy this session with you all. If at any time you need to ask any other questions or you feel that we could have a greater discussion, I am available. You can reach out to me through Abrar and we can have another session or something else at another time, right? I see somebody's hand is up. I can take one more question before I leave. Is it Ishmael?
Yes, it is. Assalamu alaikum.
Welcome, salam.
Just a few. Sheikh, for some reason, I didn't get in. From since 2 o'clock I tried. Right? I posted the question earlier concerning stepchildren.
Right.
Is it that I'm putting them in the will and they will go accordance? Or do I have to give them something?
Okay, so you can put, well, I'm not going to speak of it from the point of I'm not going to speak of it from the actual division of the property from the Islamic point of view. I'm just going to tell you legally, you can put them in your will. There's nothing wrong because they are your children, correct?
No.
No. Okay. All right. Well, I will leave that question to Mufti to answer, and I could then deal with the Islamic, the legal part of it after.
Well,
but you can include, there is a way that the inheritance is divided, yes. However, from a legal perspective, anyone can be in your will, but of course it must be accordance to the Islamic laws as well. But we are making it legal to Trinidad and Tobago, so you don't legally have to include a stepchild, but Mufti will speak about it from the Islamic point of view. Okay, so if there's any,
could I adopt them to make it legal?
I want to come in a little bit. There's a few different perspectives that you're asking there, right? So one is the legal, and legally you do have some ways to do that. One is that you just put them in your will legally,
right,
and it will be binding and it will be okay. Even adoption would be no, but if it's just stepson, that means it would have stepchildren. That means you're part, but they're
No.
not your children at all. They're
No.
both parents are someone else, and maybe you would have married into the family. So then in that case, yes, you could probably adopt as well, but then the mother would still be Soraya.
Okay, so you can adopt. Now, I missed that part in terms of the lecture with how you divide the property, specifically two-step. Right, now this will not be your child. So yes, you can leave to someone who's not your child, but I'm not certain as to how much you can leave them, right? So that's something that Mufti would have to clarify for you. You can adopt, and then they would legally become your children. And then from that perspective, then they would fall under the normal inheritance Islamically, correct?
Yeah, so Mufti Kalim, you can unmute yourself if you wanted to jump in.
Bismillah. With regards to the laws of Sharia, the Sharia differentiate between inheritance and wills, inheritance and wasiya. A person is allowed to make wasiya will to anyone. It could be even a non-Muslim, right? So in this case, if the person wants to make a will to his stepchildren who is not part of him, right? That could be made, and that would fall under the wasiya part of the net estate, right? So that would be totally permissible, right? As in wasiya, a person can make, as I mentioned, wasiya to a non-Muslim, and it'd be valid, right? So there's a difference between wasiya and inheritance. And the hadith where the Prophet mentioned, La yarithul Muslim al kafir, a Muslim will not inherit from a kafir, nor a kafir will inherit from a Muslim. That is specific to inheritance and not wills and wasiya. So yes, he can do it.
So that being mentioned, this is where, inshallah, this part of the session, we're actually opening up to more discussions, and you can ask things around personalized things. We do have some attorneys here. Soraya, first, let me finish with that part. Thank you for, actually, Soraya came on a very short notice, and we want to thank her for that, that contribution she gave to us. I think she's left now, but yes, she has another engagement at this time, so she had to leave. And again, thank you for that. So at Al-Ihsaan, we actually do this. This is what we do as well. One is the awareness that we bring, and we do actually try to help people, whether it is finding your shares, because sometimes you do need to just understand the shares to start the process, because a lot of times the process itself would entail first understanding the concepts behind it, then afterwards understanding who's supposed to be inheriting, and third is actually drafting that to keep with you. And as we know, it's something that is mentioned already. We don't really know anything about life. We don't have any guarantee how long we live. And, given the situations. I gave some examples last week where people were actually calling the funeral home to come and book their funeral and to bury them when it's time. Alhamdulillah, Allah subhanahu wa ta'ala gave them extra life so they continued living after they got the virus. So it's very important, inshallah. So that being said, I just want to continue the topic when Brother Ishmael asked about stepchildren. Now, as Mufti Kalim was explaining, wasiya is something that within your inheritance, that chunk of estate that you have, that you've left. And as I mentioned in last week's session, it starts from the socks that you have, or your miswak, or your toothbrush, straight up to every other part of property that you may have, or wealth and a bank and stocks and whatever you have. Whatever is in your name needs to come into that distribution. And as you mentioned, first it goes to the debts, the funeral arrangements, and then afterwards they start taking out and sharing according to the shares. Now from those shares, there's a 33 amount percentage that can be left for someone, or it can be left for a charity, or it can be left for a masjid, or it can be left for something that will be beneficial to the community, whatever it is. So in that portion there, as Brother Ishmael is showing, is an allowance where you can actually leave for stepchildren and children as well. Because in the inheritance, it would not be Islamic to put them in the inheritance. Because in inheritance, stepchildren do not inherit from you. But from this section of the 33%, you can actually leave them portions that will be sufficient for them, inshallah, and the rest will be for the actual heirs that is left. So like the wife, and if there's a child, or maybe a mother or father or so. So that's one way to deal with it. Some people, one of the solutions some people have found is that, like a husband will leave the house and give the house totally to the wife, because he wants his stepchildren to inherit from that house or property that he took time and effort to build. And because it was built as a family now, and the children are stepchildren, but they live as a family. So what they do is they left the entire house to the mother. So when that house is actually comes up in inheritance, it will be the inheritance will go to the children of that lady, which would be his stepchildren and maybe his children as well that he had with this wife, and so on and so forth. So for every situation, there is somewhat of a little negotiation that you can make. Kind of look at what it looked like when inheritance actually kicks in, and you can see what can be done. Another way I mentioned last week is distributing it in your life, where some people get portions and then the remaining is left for the inheritance. So these are some of solutions that you might find. So there's some questions. You can unmute yourself, or you can, inshallah. Yes, just to mention that the recording will be made available. It will be on YouTube as well. We'll cut it up a little bit more and refine it a bit more and make it a little easier for everyone to understand, inshallah. But nevertheless, we will do this, and we will keep recordings, and we'll put it in a playlist so people can access that information, and we can put it into topics so then people could, inshallah, easily grasp those topics. As I mentioned as well, and I'll place this in the email when I send it out to everyone, that Mufti Kalim has an in-depth course, which is only half an hour long sessions every week, starting in September, to understand the full extent of what it means to understand the whole topic of inheritance, inshallah. So please invite any lawyers that you might know as well, Muslim lawyers who would want to get more knowledge, to try and understand that they can, inshallah, fulfill this very important obligation of a Muslim. So let's take some of the questions. I see Amani Singh, and I see she did put go on.
Assalamu alaikum.
Salam.
Well, that's my same question. Like, what is an average cost to have a will done?
So, honestly, a lot of times for lawyers, it depends on the estate. If it's a really big estate, obviously it's going to cost more. If it's a normal medium estate with, like, for example, a house and simple things like a car and a bank account, it ranges from around $2,000 to like $3,000. That's my experience. Again, each lawyer would be able to negotiate accordingly. What we do is we try to have a service here in Al-Ihsaan where we kind of join the effort, and we ask a lawyer to overlook the wills, and we would draft it up for them and give it to them. And once they okay it and so on, then we can give you back as a will that will be sufficient and also would be relevant. It will be accepted legally and Islamically as well. So that's a service that we offer. and it's around that same pricing generally for normal. So we try to incorporate the both aspects as one of the services that we offer. So it does range around from $2,000 to $3,000, and at any given point. Once it's a simple process, it can be done like that. If it's a little bit more complicated, where a lot of times when people come for the service, they have like stacks of other siblings that they have to kind of like get first to probate an old will that was a generation before them, and they have to get others to agree to certain things. So there's a lot of complexity in it. So those are a lot more harder, and there's a lot more legal work that needs to be done first. And a lot of times it's in contention. So because of that, it's really hard to finalize. So if it's simple and straightforward, the person has full authority and it's in the names of people who can sign off on these things, then it's okay. We can be doing it in quick time, inshallah. It can be done within 2 weeks. You'll have your will in your hand, inshallah. Sister Trisha, I hope that explained the question, inshallah.
Assalamualaikum.
Thanks,
I am Muslim. My mother is Hindu, and she made a will many years ago, stating that I would get her property. I want to know if I can accept that property when she dies. Also, I we have a joint account. So I want to know if I can also accept that money in the joint account if she dies first.
Okay. So Mufti Kalim, you wanna jump in here?
Okay. As we mentioned before, there's a difference between wasiya and inheritance. So if your mother, who is non-Muslim, left a will stating, okay, when she dies, a certain part of the property would go to you, then according to the laws of the Sharia, then yes, it will be jaiz and it will be permissible, with the condition that what her legal heirs, which is what her other children or family members who are non-Muslim, they don't contest, right? They don't contest it. So meaning what? If they don't contest to that will, and they say, you know what, it's okay that you take it. It comes more like a gift then, right? It comes more like a gift than inheritance, right? So if none of the other heirs that have a legal claim to the estate is contesting for it, then it can go to you, but it will not be inheritance. It would be more like a gift or wasiya, which is jaiz and permissible.
Okay, thank you. And with the account as well.
Yeah, that would be part of the estate, right? So to have the same ruling.
Thank you. Assalamualaikum.
So it's something to mention as well, and that's a really good point. A lot of times there are some laws in Sharia that sees the actions of non-Muslims a little differently that they would see the actions of a Muslim, and because of that, there is some, as you would say, difference in the way that it would be ruled for a Muslim and a non-Muslim. So it's very important to ask that question, because a lot of times people assume that if it is a non-Muslim doing something, it's the same ruling, but it's a bit different, especially knowing that the law of the land has some type of allowance for them to do certain things. And for us, it might be required by Sharia to do it in a different way. One quick example of that is, as I mentioned, when you're in a Western country, it's very important to write that will. And Islamically, you're not really obliged to write it in full detail, because the law of Sharia is already there and Allah has already revealed it. However, when you're in a Western country, when you don't have a will written, what happens is the same thing, the intestate, you can die intestate, and then that person, the shares will be according to the law of the land and not according to Sharia. So then that becomes a problem. And similarly, when you have issues where someone is leaving a portion from the wasiya, the 33% that you're allowed to leave for someone else who's not an inheritor, then if it's not clearly done or it's not clearly stated, then that could be a problem. One of the comments I had, and anybody who have any questions, you can feel free to put it in, inshallah, and I'll still try to to answer it. One of the things someone was asking is, okay, so I mean, I have some good news as well. Some of the a lawyer just saw a message as well, and she said that you can actually get it for much lower as well for those families who have, meaning a will written up from like 750 upwards and so on, and it can go all the way up to 5,000 to 700, 7,500 and so on. Also, one of the things someone asked earlier about having a wife who is a legal wife, but she's not the wife that is there, meaning nikah is not longer there. There's no marriage. There's talaq, for example, that has taken place. Can she still? Do you still have to put her in the will? So one of the advices that came from the lawyer as well, another lawyer mentions that you don't actually have to put her in the will. What you can do is just express clearly that that person cannot get from your inheritance, and that if you make mention that that you're not leaving anything to her for this reason, that you've not been married to her Islamically and she's no longer part of your dependency and so on, that can stand legally as well. So that's one of the options that a person can have as well. So we do have 5 more minutes. I do want, as I said, anybody have any questions or discussions? I saw one in the chat here. Is there Islamic requirement with respect to number 1, number and gender of witnesses, and 2, number of gender of executors? No, you don't have any requirements Islamically. Obviously, 2 witnesses is also recommended Islamically. But that was what makes it legally binding, so that's what should be done. What is the position with an Islamic illegitimate child? So a legitimate child, if I recall, does not inherit as well. An illegitimate child, so one that was born out of wedlock, does not inherit as well. So Mufti Kareem, if you're there, you can check that and double check as far as I recall. Can you explain a bit more on the difference between wills and inheritance? So, in a simple explanation, the will is what is actually written up, that last testament that you write that distributes your property. And the inheritance is that property that now goes into inheritance, or that estate, that amount of money, that all those properties and that wealth that you had, that is now going to be shared to others. So that's what you call the inheritance, the actual shares or the money or the cash or the business or the whatever that is inherited. So inheritance again is the actual estate, and the will is what you write, that written document. So anybody have any other comments? You can feel free to unmute yourself and do so, inshallah. I just want to mention 2 last points as we close off as well. One is that understand that in Islam and in Deen, it is very important to give everyone their due. And a lot of times when we have these workshops, we have more people attending who have problems with their inheritance, and somebody else took from their property and is not giving them. And I understand the plight of many people, right? It's very sad to know that, and many people have a lot of difficulties getting their family members who would have been their own blood and so on to do the right thing. But a lot of times what we try to do, and our main focus in these workshops, is for the viewers, for you to do the right thing and for me to do the right thing, that we can write our wills, and write it, even though you might not have any kind of major large property, but do write something and leave something that would be a clear definition of what should happen after your death, especially for a person who is a new Muslim and who do not have full, Islamic or Muslims around them. You should definitely write one, and for Muslims as well. So you should definitely give everyone their due right, and that's important. Even if you are holding some property of your father or your mother, and you know that your sister, your brother is supposed to have part of it, and you're not giving it to them, then the punishment is grave. In fact, Rasulullah sallallahu alaihi wasallam mentions in a hadith here, "Man iqta'a shibran min al-ard dhulman, tuwiqa Allahu iyyahu yawm al-qiyamah min sab'i ardin." That person who takes from a portion, a little handspan of earth, of the land, for example, of someone else. So he's taking it unjustly. Zulman, he's taking it oppressively, that it's not belonging to him and he's taking it. So he somewhat usurped that. Then Allah subhanahu wa ta'ala says that that will be placed on his head like a necklace on top of his head on the day of judgment. And that will be min sab'i ardin, 7 levels of earth will be placed on his head. So something that's very important and grave in the sight of Allah subhanahu wa ta'ala as well. And we should be mindful of it. And I know that many of the people that get affected are the ones who are victims, and the ones who are perpetrators, they are the ones who don't listen and they don't want to act because the greed and the love of wealth and love of property and so on is seeping into their hearts, and they're getting distracted by it. But it's something that we should do and bring about the awareness. We never give up, inshallah. Sometimes Allah subhanahu wa ta'ala brings the light into the darkest of hearts as well, and they sometimes see the importance of doing the right thing. So that's something that with these types of workshops, and you can feel free to bring those issues, and if someone wants to talk about it and try to get a little bit more information, we'll be free and willing to do that, inshallah. I do see it has a few more questions. Yes, in the will you can decide what you put in and what not, and that's the idea, that you put in the Islamic perspective so that it stands Islamically. Inheritance is the only thing that follows Islamic rules we went through earlier. Food for thought. Illegally, what would be the effect of a will left by a person who is an adult Islamically but a minor legally? I'm not sure. Maybe if we have one of the lawyers here with us, if it is a minor and that minor writes a will and Islamically it's binding, but legally the child is a minor, would it have any effect? Well, that's if the child dies, first of all, obviously. That would be the question would come in then. I'm not sure if it would have effect or not, but definitely would have to go to the courts, and they can sometimes look into it, and if that person has document that they actually left that was done with a lawyer. A lot of times when a lawyer does it, the lawyer has ethical code to follow, right? So a lot of times when the lawyer does that, it's binding in the court as well, because they know it comes from the instruction of someone who would draft it according to the needs of the law. So sometimes it stands up in court, but I'm not sure if a minor is doing it themselves, if that would stand. I'm really not sure. I'll have to find out. I think Brother Ishmael, you had a question? The lawyer said that.
Yes. I don't want to get mixed up. Making a will is one thing and inheritance is something else, correct?
Yes.
They must work hand in hand?
Yes, yes. Practically, they have to work hand in hand because you can't really do one without the other.
Why I'm asking that is that if somebody makes a will and he could make it to any person or persons, but if the inheritance doesn't work out accordingly to the Sharia now, if you understand what I'm saying,
yeah,
he could will on to anybody,
yes.
but he doesn't do it right according to the inheritance.
Yeah, so if someone does that, which is legally possible, then they will be answerable in the Sharia. And that's the whole aspect of trying to explain the importance to Muslims to marrying those two things together and making sure that they're joint when you're doing it. Because you can't do that, and it would be binding legally, but it would not be right Islamically, and they will be answerable Islamically in hereafter. Legally, this world, people will do all the wrong things and right things too, but we have to ensure that we're doing it once with the knowledge that we have. So as we close up, inshallah, we did say we're ending at 4 o'clock. I want to thank all of you for coming. It's really, as I mentioned last time, these programs and these sessions can only be possible with your interest and with your attendance. So we, from the bottom of our hearts at Al-Ihsaan Institute, we're grateful for this, inshallah. We're grateful too. There was our host as well, co-host, Brother Samir Hussein this week. So he was part of this as well, inshallah. And we thank him. We want to thank Mufti Muhammad, who helped with some of the putting together of this workshop. And all of the people who would have given, obviously, to our special guest, Mufti Muhammad, Mufti Kali Muhammad, and Sister Suraya Lachman for making this possible as well. And again, I will send you the email for all of the slides that we did present. Some of the ebooks that we did, and you did have that as well. So if anybody didn't do that, please send us a message on WhatsApp. On the top of the chat here in the chat in the Zoom here, you have our office number, so you can just give us a message and we will send you the information if you did not register. So make sure and send us your email that you want the information. We'll also send you the link for these recorded sessions and you'll be able to see it, inshallah. So the link will be on YouTube and it will be made open, inshallah, so you can actually view it. And lastly, most importantly, is the action time, inshallah. So we need to act upon it. If you do have the need to write a will and you just want simple advice, you can call and book in an appointment, inshallah. I'll make myself available to look at your personalized situation. Also, we can get some advice from lawyers as well. There are many lawyers who are willing to help, inshallah. And lastly is that you should write a will and make sure that it is Sharia compliant. And we will help you with that process. You can feel free to book that. I did put a link as well, and I will put that in the email as well. So if you want that full service, please register on the link that we will send to you on your email, and we could make an appointment and start that process, inshallah. So may Allah subhanahu wa ta'ala accept you all, accept all of the people who attended and make this possible. Jazakumullah khairah. And until next time, please look out for all of the sessions that we're doing. We want to start up a series on marriage and divorce because that's one of the big issues in society as well. And similarly, there's a lot of laws and rules in Sharia explaining those aspects of marriage and divorce and how it should be and what you should say and what you shouldn't say, and how you should have property arrangements and so on, and how you should have wealth arrangements, and how you should have custody arrangements, and all of these things are very much detailed in Sharia. So the more we know about it, inshallah, the more we'll act upon it, and we can save ourselves so much discord and disharmony that is spread in the world without following the laws of Islam. So may Allah subhanahu wa ta'ala accept you all, strengthen us, keep us safe, and strengthen our iman, and all of those people who are going through any type of difficulty, whether it be these types of legal issues, property issues, financial issues, health issues. May Allah subhanahu wa ta'ala alleviate their difficulties and hardships and make it easy for them and take away any type of hardship and difficulty that they're facing. Until next time, أقول قولي هذا أستغفر الله لي ولكم ولسائر المسلمين فاستغفروه إنه هو الغفور الرحيم. السلام عليكم ورحمة الله وبركاته.
وعليكم السلام.